Hello and welcome to the Kenneth A. Vercammen Law Office Legal Podcast. In this edition, we look at domestic violence law in New Jersey. In New Jersey, domestic violence laws are very strict. If the police are called, if there's any signs of physical injury, the police must arrest the potential abuser. Even without independent witnesses and no physical injuries, police may arrest the abuser. Domestic violence is also a crime under the law, and police must respond to the call of victims. Police are required to give the victim information regarding their rights and to help them. Among other things, police must write up a report. For example, in New Jersey, OJ would not have gotten away with abuse in New Jersey. Police are required to automatically arrest an abuser if they see any evidence of abuse or assault. So during an evening, your town municipal court or superior court can issue a civil restraining order, which is a legally enforceable document. The temporary restraining order will prohibit the defendant abuser from harassing the victim or entering the residence. Unlike a criminal case where a defendant is provided with lengthy due process and if guilty receives probation and monetary fine, domestic violence hearings allow a judge to issue far-reaching orders. A domestic violence hearing is usually held within 10 days of the filing of an ex parte complaint and temporary restraining order. After a hearing, the New Jersey Statute 2C:25-29B allows a Chancery Division family part judge to grant substantial relief to the complainant. So if someone is charged with a domestic violence complaint, it is important that they right away seek legal representation, either to defend the charge or to minimize what the judge might impose. At the hearing, the judge of the family part may issue an order granting any or all of the following relief. 1. An order granting restraining the defendant from subjecting the victim to domestic violence or any contact at all. 2. An order granting exclusive possession to the plaintiff of the resident or household, regardless of whether the resident or household is jointly or solely owned by the parties or jointly or solely leased. It doesn't affect title, and I'd say it could even be where the victim's allowed to stay in a property that's solely owned by the defendant. 3, the judge can provide for an order for parenting time or visitation. I'd say the judge can also deny visitation for a period of time until the abuser undergoes certain types of either treatment or domestic violence counseling. I'd say the judge could also order the victim to receive monetary compensation from the defendant for losses suffered as a result of the act of domestic violence. I'd say the order may require the defendant to pay the victim directly. 5, the judge can order that the defendant receive professional domestic violence counseling at either a private source or one ordered by the courts. I'd say, and 6, after judges hear this case, they can also bar the defendant from entering the residence, property, school, or place of employment of the victim. I'd say, and also order that the defendant stay away from household members of the victim or family of the victim. 7, they can issue an order restraining the defendant from making any contact with the plaintiff or others, I'd say, or through their agent. 8, they can order the defendant to continue to make rent or mortgage payments of the resident occupied by the victim, even if the defendant is no longer living there. 9, they can order the defendant to provide temporary possession of certain personal property to the victim, such as an automobile, checkbook, or other personal effects. 10, they can award emergent monetary relief, including support for the children, the victim, and other defendants, and it stays in effect until modified by a judge later on. 11, they can award temporary custody of a child, and they can also order that the law enforcement officer in that town accompany the defendant to the residence or a business premise to supervise removal of personal belongings, but usually that's only for half an hour or an hour, so all the defendant will get is a short period of time. Let's see. Now there's many other things that the court can order, even a psychiatric evaluation. So, and since portions of these are confidential, it's important that if someone's charged with these, they seek the advice of an attorney, because typically these go to court within 10 days. Let's say if someone is charged with a domestic violence complaint or a criminal charge such as harassment, assault, or making threats as a result of the domestic matter, call the law office of Kenneth Vercammen, 732-572-0500. Also 1-800-NJ-LAWS-7. That's 800-NJ-LAWS-7. We're at 2053 Woodbridge Avenue, Edison, New Jersey, 08817. On the web at www.njlaws.com. That's njlaws.com. And also at benotguilty.com. That's benotguilty.com. Thank you and good luck.